All right, Supreme Court of Law session, the Honorable Chief Justice Robert J. Torres presiding.
Hafaday, good morning. You may be seated, counsel. Will the clerk please call the case?
This is Supreme Court case number CRA25-007, People of Guam Plaintiff Appellee v. Michael Carlo Basilio Badar, Defendant Appellant. Appearing for Defendant Appellant is Attorney Peter C. Perez. Appearing for Plaintiff Appellee is Attorney George Ray Cole. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carvalito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Perez reserves 10 minutes.
You may proceed, Mr. Perez.
Good morning, Chief Justice Torres, Justice Merriman, Justice Carvalito. May it please the court. We've raised two issues on appeal in this matter. And the first is sufficiency of the evidence. And I would start by saying I've never seen a case like this before, where we have a defendant charged with possession of a Schedule II controlled substance and with the people presenting for admission absolutely no exhibit. We have people referenced 3 exhibits during the examination of witnesses, but none of those exhibits were offered into or admitted into evidence.
Mr. Perez, perhaps having the actual drug in the courtroom is the best evidence, but why is it not sufficient that there was testimony that the defendant possessed those drugs?
So we have the court's prior decision in Mateo, which referenced People versus McKinney and a string of cases from other jurisdictions, which state that, a case can be proved entirely on circumstantial evidence, and that applies also to drug cases. And yes, perhaps it's not absolutely, well, the court has found that it's not absolutely essential that the drugs come in. However, in looking at this case specifically and comparing it to, for example, Mateo and other cases, what do we have in this case? We have testimony of marshals and officers who say that they were executing a warrant that Mr. Badar was hiding when they were executing it. And at one point, a baggie fell out of his shirt. And then later, when he was patted down, they found another baggie in his shorts. And there's testimony regarding field tests. There's testimony from the criminalist who said that they did lab testing. But we don't have, I've just never seen this. And, I guess it's for the court to determine, is it enough to sustain a conviction solely on testimony without any underlying exhibits? And my concern really is, what would be the precedent and how far would that be taken in other not only this prosecution, but others? Could an officer simply go in and say, I approached a defendant, the defendant had a baggie, the baggie appeared to me based upon my experience as an officer to be crystalline, and in my opinion, that was methamphetamine. I did a field test. By the way, this court said field tests alone are not sufficient to establish guilt beyond a reasonable doubt. And it's my opinion that he possessed a controlled substance. Would that be sufficient? And I would submit it would not be, notwithstanding this court's prior holdings.
So why wouldn't, understanding your summary of what is the evidence that was introduced in terms of circumstantial evidence, but I want to focus on criminalist Harris, because he seemed his purpose was to testify in reference to the confirmatory test that the crystallized substance in the bags were amphetamine based. So what was the shortcoming of his, if that was the case, the testimony of Mr. Paris?
Now, it wasn't objected to at trial, but in retrospect, one of the concerns would have been a lack of foundation. Because he's testifying to testing substances which had not been admitted into evidence. So in further answer to Your Honor's earlier question about do we have to have the drug evidence at trial, to the extent that a foundation needs to be laid for an expert to testify to what they tested, I think there would have been a lack of foundation.
Yeah, but all that was waived because there was no objection at the trial level. So assuming that that is not an issue, and his testimony, his testimony is on the record. He testified as to the substances in the bags, that they were amphetamine based. Wouldn't that be sufficient to confirm the presumptive field tests that the officers who testified that they seized these drug-like substances and they tested it out in the field with the presumptive field tests, the coloring agent or tests, and that preliminarily showed through the changing of from, I guess, orange to brown, that is a presumptive amphetamine-based substance.
What if the conviction is sustained on that basis, I think what it means is that the government can present a case entirely on testimony without any underlying physical evidence. And the theory of the government's case, the charge, is that there was possession of a Schedule II controlled substance. So yes, while there's testimony about the testing, the field test, the circumstances under which the baggies were discovered, that exists. But I've never seen a case where the actual exhibits had never been offered or introduced into evidence. And I think for not only for this case, but for precedential purposes, would that mean that that's all the government ever needs to do in maybe not only a drug case, but with respect to a special allegation, with respect to a murder case? I just think the potential precedent goes quite far.
Well, I think your point is well taken, that this may not be the best practice of proving that in this particular case, it's just that the items seized were amphetamine, and there were drugs that were allegedly in those bags that fell out of the sleeve was found in the pocket. And so the challenge here that you pointed out, we held that the presumptive field test in and of itself is not sufficient to prove beyond a reasonable doubt that the substance is an illegal substance. And that there must be circumstantial evidence, we said, through either direct or circumstantial evidence in reference to testimony, pictures, and most clearly would be the confirming lab tests. And I understand your argument that the actual exhibits and drugs were not introduced, but the argument by the people is there's sufficient circumstantial evidence to prove that the items seized in those bags were amphetamine based on a presumptive field test and presumably a confirmatory test in the lab by criminals Harris, if in fact that's what he did.
It's really kind of a case where the government talked about the evidence through its witnesses, but never presented the evidence. And
What was the testimony of criminalist Ed Paris regarding the methamphetamine here? Did he talk about the confirmatory lab or testified to the confirmatory testing that was actually conducted and explain all of that? Or was he just describing the methods and results of the presumptive color tests?
he talked about, well, first of all, his testimony needed to be refreshed by presentation of exhibits 2 and 3. But in answer to the question, he talked about having analyzed the items. He said that he tested the crystalline substances in the bags. And that he prepared lab reports determining that they were methamphetamine. But the lab reports themselves were not introduced into evidence. We have his testimony, but we don't have the lab reports. We don't have, there's reference to chains of custody, but we don't have the custody receipts coming in to establish that what he tested actually came from Mr. Badar. I think that broad principle about cases being able to be proved entirely circumstantially, even in drug cases, I think if applied in this case, when we look at the facts, I think it might go too far. And, when we look at, for example, the Mateo case, and we look at how the court sustained that conviction, even though there were not scientific lab reports introduced, that was a case where we had a police officer testifying to a traffic stop, seizing ice pipes, and then a defendant making 2 statements and making 2 admissions to possessing, talking about how he was collecting on behalf of Mr. Splan, how he was attempting to do transactions that day, how he had used that day. And the government actually had produced photographs of the alleged substance at trial. And those facts are quite different from these facts where we have no admissions, we have no statements, we have absolutely no exhibits. We have testimony talking about evidence that never came in before the jury. And, I'm not sure what else I can say. I think that Mateo is distinguishable, and Turner, the Seventh Circuit Turner case that people referred to as distinguishable, because in Turner, my reading of it is they actually submitted the drug evidence at trial, and the concern was with respect to the expert. And it was a confrontation issue, but even in that case, we had, I believe, the drug exhibits admitted. We had conversations between Turner and law enforcement regarding transactions, including prices and transaction details. We had witness descriptions of the alleged drugs that Turner distributed. So I'm just not sure how far precedent the court would want to establish.
But are you arguing in court today that in order for the government to prove that the items seized were illegal drugs, that it was mandatory that they produce the substance in court and admit exhibits of the actual seized items in the trial, that there cannot be a case where there is a narrative in reference to what was seized out in the field and what type of tests were administered, and that would be sufficient to prove that the items were amphetamine based.
I do think at a minimum, the government should be, yes, I think they should be presenting into evidence, having it admitted, the alleged drugs themselves, for the jury to view. I know that there's argument that the Mateo case might not require that, and I know that there's other cases that might not require that, but I've never seen a case in federal court where the government has not brought in the drugs and as a precedent to an expert testifying. And, I tried to look for cases in our court which dealt with this issue, and we do have the Mateo case. But, the facts of that case are different than this case. So I think on the specific facts of this case, the evidence was insufficient. No drugs, no chain of custody, no lab reports. We just have people talking about evidence that was never admitted. Circumstantial, yes. Is it sufficient? I would submit no. But I guess that's the issue for the court. If there's no questions on that, then I would go to the next issue, which is improper commentary on my client's silence in violation of his Fifth Amendment right to remain silent and not to testify against himself.
Before you do that, what would be the appropriate standard of review where there's been objection to some statements, but not objection to other statements?
Well, we've asserted on this appeal that it would be de novo review, and there was not an objection made during the statements made during opening statements. But there were objections made during the actual testimony that were overruled and allowed to come in without any limiting instructions. So I guess one way the court might look at it is to apply a de novo review to portions that were objected to and plain error to those that were not objected to. But that would be one approach. But the other way to look at it is this structural error insofar as we're talking about a defendant's Fifth Amendment right to remain silent and for there not to be any commentary regarding that invocation. So I would submit it's de novo review.
So, Mr. Paris, sometimes in the course of testimony, an officer will say he didn't answer any questions, and they view that as an answer relating to how the investigation proceeded. How is, you seem to be saying this is different in this case?
Well, one of the first comments that I think it is, one of the first comments made during opening statement, if we look at the transcript, there are prefatory remarks. This is on page 7 of the transcript. There's a prefatory paragraph regarding an outline of what the government intends to present. And then they go to a section on line 20 where they say, but the actual facts of this case, starting toward the beginning, is that this gentleman was wanted for questioning on an unrelated matter. So it does talk about an unrelated matter, but it does bring up the issue that he was wanted for questioning. And when we get into the substance of the questioning, the testimony was, Badar was wanted for questioning. He had been hiding from police. GPD wanted to talk to Mr. Badar. He did not wish to talk to police. Badar refused the interview with Detective Raval. And this is in the context of, yes, while he was being wanted for questioning in an unrelated case, it was happening at the same time that baggies were discovered on his person. And he had made no, there was no contraband around him, there was no paraphernalia around him. But here's a fact. We found a baggie, it fell out of his shirt. Here's another fact. We patted him down and we found a baggie. Meanwhile, there's testimony, and I'll concede, we have to look at the chronology, but there's this discussion about him not wanting to be interviewed and not submitting.
Wasn't that all in the opening statement? I think what Justice Merriman was talking about was the police officer's testimony.
Yes.
Those questions. I mean, what you were referring to, he didn't wish to talk to police. He refused the interview. Those were all in the opening statements.
It was during officer testimony also. It was
I thought the officer testimony was more related to whether he submitted to the interview and then when he didn't, he was arrested.
It's on page 9 of our, it's on page, let's see. It's on ER 35 to 36. We have Mary Jane Rovell, Detective Rovell testifying. And she's asked, so once he's brought in, what did you do? We transported him to the DART office in Teton, and I attempted to question him there. And did he submit to interview? Objection, Your Honor, may not comment on my client's right to remain silent. AG, I mean, it's not that important. It's just the court overruled. Go ahead and ask the question. AG, so did he submit to the interview when you were attempting to interview him? Defense, same objection, Your Honor. She can move on. Court overruled. Go ahead and ask the question. Question, did Mr. Badar submit to that interview? Answer, no, ma'am. So once he didn't do that, what happened? Answer, he was arrested. And in that process, what did you do? I informed him that he was being arrested for, and we transported him to the Department of Corrections. Okay, and so before that transport, there's a procedure, correct? He was processed, fingerprinted, and photographed. And were you the person who did that process? No, not me. Who did that? Let me move on.
Right.
Question. So in any event, he was brought to you for the interview and then you were going to transport him to DOC, correct? Yes, ma'am. So that was the substance of the commentary in the trial. There were prefatory remarks in the opening. They were not objected to. There were repeated objections to the commentary during the testimony. Now, one of the concerns is what we have is we have the defendant's silence in the face of the purported baggies being discovered. And, you know, Detective Rovell's testimony, a large part of that was devoted to this back and forth about the interview. And, you know, I think when we have a case where the evidence, we argue, is not sufficient, and where this testimony is, let me just back up and if we look at the standards, there's the Fifth Amendment, which says that, you know, individuals can't be compelled in a criminal case to be witnesses against themselves. We have the Miranda and Griffin cases, which hold that the Fifth Amendment forbids comment by the prosecution of an accused silence or instruction by the court that such silence is evidence of guilt, and that it applies even to pre-trial silence. And then we have this court's analyses in the People versus Cruz and People versus Moses cases, where this court has held that a defendant's right to self-incrimination is violated only when, one, it was the prosecutor's manifest intention to refer to the defendant's silence, or two, the remark was of such a character that the jury would naturally and necessarily take it to be a comment on the defendant's silence. If the Attorney General said it wasn't important and continued to ask the question and make the point, I would argue that it was the intention to make a point of the defendant's silence. And as to the second factor, in light of the manner in which this case was presented and looking at the evidence that was presented, I would submit that the remark was of such a character that a jury would infer that this silence demonstrates guilt. He had the opportunity to comment when these baggies were found and he didn't. And, you know, the fact that there had to be multiple objections and they were overruled multiple times and there was no limiting instruction, I think is concerning.
So what are the remedies, or what remedy are you seeking for these alleged violations that you are bringing forward to the court?
On both issues or this issue, Your Honor?
Both issues.
Vacation of the judgment, reversal and vacation of the judgment, and with prejudice.
In reference to the insufficient evidence.
Insufficiency, yes, and Fifth Amendment violation.
What about as far as the Fifth Amendment?
Same.
Why would the Fifth Amendment violation, if we agree with you and vacate the conviction, why would that result in a dismissal of it rather than a retrial?
Well, one, because we've got a Fifth Amendment violation. We've got a defendant, we've got purposeful conduct. I didn't argue prosecutorial misconduct, but it's not proper conduct for,
I mean, I understand insufficiency of the evidence in reference to what remedy you are seeking. In reference to a vacation of eviction and dismissal. Or an acquittal and dismissal. But in the Fifth Amendment violation, I don't see that.
if and I don't want to misspeak, so if the remedies that have been imposed in Fifth Amendment violation cases have not been reversal with prejudice, and it's been a new trial, if that's what the remedy is, then I would ask for that to be the remedy. But if as I'm arguing that it could be a vacation of the judgment with prejudice, that's what I would ask for. It's not a question I anticipated and am not prepared to answer definitively. As to the insufficiency, though, I think that would be a reversal with prejudice. If there are no other.
Your time.
Okay. Thank you.
You have 5 minutes. We'll give you 5 minutes. Mr. Cole?
So. Chief Justice, Justices, please the court. Under the established standard of review, which is, I agree, is de novo here, which is articulated in Anastasio and also in Worcester by this court, which means the question on appeal is whether crediting all of the people's evidence and drawing every reasonable inference in favor of the prosecution, whether a rational trier of fact could find the defendant guilty beyond reasonable doubt. I think the answer
Was the identity of the controlled substance, the alleged controlled substance, established through more than the presumptive field tests and visual identification? And what was that evidence?
Well, I think, of course, the field application both said it was meth, and I think as a.
Right, but we've already said that field tests alone are not sufficient, right?
That's correct, Your Honor. There'd be more, and I think the testimony of several officers is enough, more than enough to justify the sufficiency of the evidence. But the other test that you're talking about, that Mr. President was talking about.
What, just their visual identification of it?
Yeah, I'm sorry. Yes, sir. There were two. There were both the officers that were all, and I think.
So you think the government can prove a drug case with just the reagent testing and visual identification by an officer, that's sufficient?
Depending on the facts, but yes, sir, I think that's obviously that's minimum, but I think that's sufficient. Particularly if you have more than one officer testifying to it, because there were like 3 or 4 officers involved, and they all testified that it's clearly something they thought that was tested.
Yeah, but aren't there inherent limitations associated with the color testing and presumptive field tests where it's been proven that a significant percentage of them are inaccurate? I mean, it's not intended to be the foolproof method, and that's why they have the later laboratory testing that's done on the item. And so if there's a mistake made on the reagent, even though it may look like crystal methamphetamine, so you're saying that just because an officer identifies it, even if it might be mistaken, that they've proven it?
Well, I think that's a decision for the jury to decide. They hear the testimony of the officer and they hear about the results. Ideally, of course, I'd like to have the test, the facility as well, but
was there any other testimony, like he exhibited symptoms consistent with the methamphetamine use? Was there any drug paraphernalia that was found? Was there a pipe? Any of that?
I don't recall anything else being found, just the drugs, Your Honor.
What is your best case for supporting what you're saying, that the testimony of the officers is sufficient to establish beyond a reasonable doubt that that the items seized were impediment based. What's the authority that where you are basing your statements on this morning?
I'm basing it permanently on this court's decision in Mateo. The presumptive positive result from a field test is corroborative of the defendant's possession of a controlled substance. That a conviction in a drug possession case can rest entirely on circumstantial evidence, which of course would be the testimony of the police officers.
But as Mr. Perez indicated, the
Yes.
facts of this case is different from Mateo. In Mateo, you had testimony of the defendant saying that he took drugs. You had the exhibits of paraphernalia, pictures of paraphernalia, pictures of the drugs itself that were admitted into court. So there you had, and then the officers conducted a presumptive field test. And so you had the presumptive field test, and then you had corroborating evidence through the testimony of the defendant, the pictures, the exhibits of the drugs.
Yes, sir.
Mr. Perez said that's not the case here. So how can you say that Mateo supports your argument in this particular?
I think for two reasons, Your Honor. First off, I think the bare minimum is, this case, it's the bare minimum, but it's enough to reach the status. But I think partly because it wasn't objected to, so the review is at least de novo. And therefore, as this court stated, that crediting all the people's evidence and drawing every reasonable inference in favor of the prosecution, a rational trier of fact could find the defendant guilty. I think that's the edge here, because you're looking at it in favor of the prosecution, most favorable. And I think in that situation, you have enough evidence. You have the drug testing twice. You have the testimony of several officers who have experience recognizing
Yeah,
drugs.
but all that is just establishing the presumptive.
Yes, sir.
The results of the presumptive test, that preliminarily that the items that were seized from the defendant were amphetamine based, but as what evidence or what testimony, what evidence, because there was nothing, no exhibits introduced, as Paris said,
Yes.
confirm that, is that, as we said in the tale, that was in and of itself not sufficient just to have the presumptive field test.
Right.
So what was the confirming evidence here to support that the item seized were amphetamine based drugs?
Well, the only evidence that we have here is the testimony of the officers, nothing else.
But which officer, you just,
okay, I'm
you're
sorry.
talking very general. Let's talk about
Okay.
the criminalist, Mr. Ed Harris. What was his testimony?
I think he testified that it was, no, I don't know, Your Honor.
What was the
Yeah.
process that he engaged in? And did he testify as to any results of what lab tests he performed?
I don't know, Your Honor. I thought he did testify, but I can't find where it's at. I think he testified that.
It's on the testimony of December 23rd, 2024, jury trial day 1. And his testimony can be found on pages starting, I think, in page I just had it up here a second ago. Starting on page number 48.
I don't have it in front of me, Your Honor. I apologize.
Okay.
So do you have any argument
The-
to why what was the corroborating evidence in addition to the field tests that were testified to?
I can go into more detail about the field test. I mean, what the officer said, what they did, but that's all I have. That was just the testimony of the officers and the field test.
What about the laboratory results? Those weren't admitted into evidence, were they?
They were not, Your Honor. And I agree, this is the bare minimum. That,
But when I reviewed Miss Officer Paris's testimony,
yes, ma'am.
I can't find where he ever identified that these drugs he was testing came from the defendant. There's no offer of proof as to where they came from, tying it to the case that was before the court.
That would be the officers, I believe, Law and the other officer, I think, Kogo, I'm not sure how you pronounce that. They testified that they saw the drug personally, took it to appropriate people, and that took test, they gave it to present test. That was my understanding of what happened. So testimony of whose drugs it was would be the officer that were there in person who saw them fall out of his sleeve, fall out of it. He got out of his pocket. There's testimony that he had the drugs on him personally. And then the testing, once they gave it to the criminals to do that, he tested it. Put that testimony together, you have that he was in possession of methamphetamines. That's what I would put it.
All right, what about on the Fifth Amendment argument? What would the
Yes.
standard of review there be when there is an objection to part of the testimony, or like, but no objection to the prosecutor's opening statements?
I believe de novo is also correct, but I'm not positive, Your Honor. That's what I would say. My argument would be that challenge Mark's doing opening statement and a brief portion of Raval's testimony, where the prosecutor merely recounted the sequence of investigation. These isolated references didn't constitute a Griffin violation because they were not manifestly intended to comment on the defense silence, nor were they of such character that the jury would naturally necessarily take them to be comments on the failure to testify. As you're quoting from, yes.
Detective Raval's testimony,
Yes, sir.
I mean, what was the reason for her testimony? It didn't seem like there was much substance involved with her testimony beyond commenting on his refusal to do the interview and then getting him arrested. I mean,
Well, I agree with that, Your Honor. I thought they just talked about how the case proceeded.
I mean, so
Yeah.
I mean, why bring her other than to comment on that? It seems like that was, shows that there was an intent to, a manifest intent to comment on his silence. I mean, what was the reason to bring her testimony in?
I think it was the showing how the case proceeded the entire way. She talked to him, asked the if he would talk to her. He said no. Then and her response was, "No, ma'am." Did he talk? And that was it. They didn't pursue it. They didn't say, "Did you get an inference for that? Did you think he was trying to hide something?" Nothing like that happened. And they kept moving on. They said, "What happens next?" He got arrested and was sent over to the Department of Corrections, and that's it. So that seemed like, yes, ma'am.
But this interview took place at the DART office, which is the related matter. It didn't have anything to do with the drugs. So why did they have to bring her in?
I don't understand the question, Your Honor. Sorry.
Oh. So this officer was asked, I think, seeking to ask questions about the related matter,
Yes.
not this prosecution, not the drugs. So why even call her as a witness? It's not related to the case before the court.
Well, I mean, the question, because she asked him about it. I mean, just to see if he was going to talk to her, which is, I think, a good detective would do, or a good officer would do, to find out, is he going to talk about it? Is he going to admit it? He did. She didn't push it. She didn't ask for any inferences about whether he seemed like he was trying to hide something. One question she said, "No, ma'am," and that was it. And then the question was over soon after that. I would also point out that the prosecutor didn't, or the AG didn't even bring up the matter in the closing arguments. It was covered in, they mentioned it briefly in the opening, then asked this question, he said, "No, no, ma'am." That was it. Didn't come up at all anywhere else. So I don't think it was really part of their position to try and insinuate that he was trying to hide something. They're just trying to show how the case moved forward, cover every base. That'd be my argument, Your Honors. That's all I have.
If you have nothing further, thank you, Mr. Paris.
Thank you, Your Honors.
Mr. Paris, you have 5 minutes remaining.
Your Honor, I don't have anything further unless the court has questions.
I have no further questions. We have no further questions. Thank you, Mr. Paris. The court will take the matter under advisement, will now stand adjourned and will issue a written opinion.
All right.